For David Clendon.
Thank you, Mr Speaker, and I'm pleased to speak on behalf of the Greens to this Insolvency Practitioners Bill. And it's been useful hearing some of the contributions so far, and in particular to hear some of the background, the history to this, because clearly there has been a problem here for some time, and this is the latest attempt to address that problem. Now, the bill clearly sets out to create a negative licensing system, giving the registrar of companies the authority to restrict certain individuals from providing or continuing to provide corporate insolvency services. And the registrar would be able to take into account failures to comply for the previous 5 years and move to prohibit a receiver from practising for up to 5 years, or to require them to practice under the supervision of somebody who's acceptable to the registrar. And there's also a provision in the bill for receivers to have a right to appeal any move to put them on a negative register, which is only appropriate given it could be a matter of livelihood for some of these practitioners. The nature of the problem being addressed here is spelled out in the explanatory note to the bill, and that is that the process involved in liquidating companies, that is, in dealing with voluntary administrations or receiverships, require that practitioners do possess a high level of knowledge, a high level of skill and an equally high level of integrity to ensure the best outcomes for all the parties affected in these cases. Reference is also made to a general consensus among practitioners and observers generally that a small number of their peers cannot be relied upon to perform or to provide or exercise adequate care, and that those practitioners, that small number of practitioners, are constantly and continuously underperforming. The law as it currently stands offered only very limited restrictions on who can be appointed as a liquidator, as a receiver, and it seemed as possible and perhaps even inevitable that on occasion practitioners with very little knowledge of commercial law or the procedures set out in the relevant legislation can be appointed to manage or wind up an insolvent company. And that general view has clearly been reflected in some of the comments we've already heard. And finally, it is clearly noted that some practitioners currently appointed do repeatedly fail to discharge their statutory obligations to creditors, and in ways, as expressed by the Minister, that are certainly unethical and must border on the illegal practices that were described. The solution proposed in this bill is that practitioners whose work is deemed to be inadequate or who fail to comply with their duties to their clients can be prohibited from acting in this capacity or be obliged to work under supervision. And the argument is made that the industry is too small, the sector is too small, having only 100 or so, or somewhere between 100 and 200 practitioners, for it to warrant the establishment of a positive upfront accreditation or licensing system, and that such an approach would not be cost effective. The point is made, however, in the bill that setting up the registration or some sort of an accreditation system would cost to the tune of several $100,000 a year per practitioner to operate. And the question is raised that given that the practitioners are priority creditors in the winding up of a company, this cost would further deplete the limited funds available to creditors. Now, I would question that view. I would appreciate clarification on that view. That would suggest that each practitioner would do one event that would indeed take funding of several $1,000s in each case, in each insolvency. And surely, in fact, the practitioner would be registered once. There would be a cost to maintaining a register. So, in fact, it would not be that in each event there would be cost imposed on the funds available from a dissolution or receivership. It's also observed that there will be some cost in establishing a register of people who have been banned, who have been prevented or suspended from practice. Indeed, that cost would be borne by the registrar. An appeal to short-term cost savings cannot disguise the key point and our key objection to this bill, that the remedy proposed is a classic bottom-of-the-cliff approach. It waits for a person to demonstrate their inadequacy, rather than establishing in advance that a person does have the necessary qualifications, skill, ability, the confidence of their peers, the integrity to practice and to deal with issues at this level. And it's our view that short-term cost savings are seldom appropriate drivers for good policy. Clearly there would be costs involved in the supervision of those who had failed to perform adequately and who are deemed to be in suspension or only operating at the under the supervision of the registrar or somebody appointed by him. So that dollar figure that's suggested of a few $1,000s a year to manage a positive accreditation program is clearly a gross figure, not a net one. The reactive measure that waiting for trouble to occur before responding will simply see costs transferred from the upfront creation, management and maintenance of a positive accreditation system could quite conceivably lead to costly and after-the-fact court proceedings. This would seem to be opening a door, creating the possibility that only those creditors wealthy enough to afford to go to the courts will have the opportunity to protect their interests from bad receivers, from incompetent or practitioners who lack integrity in their work. A positive accreditation system, an upfront licensing, some sort of regime to accredit individuals or companies is commonplace across a range of professions and indeed trades. 50, 100, fewer of them 200. Small numbers, admittedly, but the principle is such that no one would go to a barrister or a lawyer who wasn't properly accredited. Real estate agents are required to be accredited. Tradespeople, plumbers and builders are required to be accredited. Why would this significant practice, this area of practice, be any difficult? The scale alone of some of the situations dealt with by practitioners should provide sufficient reason to demand an upfront assurance that the quality and integrity of the service providers has been evaluated. Receiverships are routinely dealing with millions of dollars worth of assets and or debts, and the consequences of inadequate or inappropriate decisions and actions on the part of the practitioners can be devastating for the affected parties. Clearly, no licensing or accreditation system can provide 100% reassurance and witness the fall from grace of, on occasion, of lawyers and others involved in accounting and legal practice and the like. But nevertheless, it seems perverse to put a reactionary after-the-event mechanism in place in the hope that it will provide adequate protection. The receiver's duties involve significant levels of trust and integrity. A positive licensing and accreditation system would not be out of place for a financial service in a country in which the general public have very little confidence in that industry. It's essential that such confidence is established. We acknowledge there is a problem to be solved, but the Greens do not see the solution in this bill and so will not support it moving beyond this first reading. Thank you.
The question is that the...
Mr. Speaker.
Your Honour.